Hi guys, it's Kathy. I hope you're doing well. We made it to Tuesday. Double day. Yay. All right, we're on day 3 of this crazy lawyer hearing. It starts already in action. So remember yesterday? No, I know you don't, but yesterday we were talking about when they do talk about some of the lawyer testimony, that this guy, he sued a bunch of lawyers, and that's confidential. So they can't live stream that. I assume they were going over that. I don't know, but this is where we're at. It's fine. We get to hear. We're going to hear from a lawyer for a few minutes, and then Aaron Bell's going to take the stand again, and his lawyer is going to start questioning him. And it gets interesting. Here we go.
Many of them, state and federal, correct?
Not as many state as federal.
Okay.
I've had many cases in federal court, and then the state court, that it's because of the way they have it set up with the team leaders and so forth, because, in federal cases, you have a judge assigned to a case, and they're assigned to it from beginning to end. It's not the same way in the state court.
Okay, well, outside of your professional relationship, what about personal relationship? You have personal relationships with these judges and their relatives?
No.
None at all?
No.
Tell me, is it common for former clerks to, the law department, do they frequently hire former clerks of local, state, and federal judges?
I only know of a handful in my unit who came from clerkships.
Yeah.
As far as the law department in general, I don't know the answer to that.
And you said you know a few in your unit, what judges sent their clerks?
I'm going to object. I don't see the relevance of this line of question.
We'll let it go a bit longer.
Judge Strawbridge, who's retired, he was a U.S. magistrate judge. The late Judge Prater. Let me see who else. Judge Goldberg, has recently, I think, stepped down from the bench. That's the only ones I can think of off the top of my head.
But you are aware that there are more? You would agree?
No, I'm not aware.
You're not aware? Okay. Out of the ones that you know, is it common for those clerks to remain close to the judges that they previously clerked for?
I want to object. This is speculation.
You're going to get to a point soon, Becca?
Yes.
Okay. Overruled.
I'm sorry, you asked me what again?
Is it common for those former clerks to remain close with the judges that they previously clerked for?
I have absolutely no idea.
Bill's here. Hi, Bill. Hi, Bill. Bill, I miss you. I haven't talked to you in so long. I know I sent you some obnoxious texts yesterday, but that doesn't really count. Poor Bill works so hard.
You would agree that it's beneficial for the law department to have attorneys that the judges find familiar?
Objection.
Overruled.
You want me to agree with that?
You would agree?
No, I don't agree with that.
Okay. So you don't think the relationship is beneficial if an attorney for the law department is going in front of a judge that they clerk for?
No.
Okay, but if you were aware of that relationship, you would notify the parties? All parties involved?
Would I?
Yes, if you were aware
I never
that one of
clerked for
the
a
clerks
judge.
in your unit, are you aware, I'm sorry, if you are aware that one of the lawyers in your unit clerked for a judge, that they are before in a matter, would you alert all the parties involved?
Would I?
If they're in your unit, yes.
No, it's not my responsibility.
Would you advise them to do so?
I'm not sure, really quite sure what you mean by that. You're suggesting I'm a supervisor?
You just said my unit. I'm talking about lawyers that you spoke of. You say 3 lawyers in your unit that work for or clerk for judges. If one of those lawyers was,
I'm pretty sure that they would notify, or let the other parties know. I have no reason to think they would.
they wouldn't, but it would be your advice that they should.
Yeah, sure. Just like me serving as an arbitrator, I do that. I just make disclosures that I may have worked in a case with an opposing counsel, with one of the counsels in the arbitration. I would do that.
You would do that, right? So it doesn't give you.
You're actually required to. You're actually required to.
Awesome. Do you remember the case Bell v. O'Connor?
Bell versus who?
O'Connor.
I have no idea. I know nothing about that case.
Nothing about that case. Tell me, do you, when did you first meet Mr. Bell?
It was one of these 2 cases. This Ramito case, and what was the other one?
Bill's driving, so he
Kim Moore,
cannot
that
text,
case I think I had.
but he
Yeah.
can listen, so we can say whatever we want
Those
about it.
cases were filed around the same time, so that's when I first met Mr. Bell.
So,
Can he clarify, Mr. Duckett, if I could, can he clarify what cases he's talking about? I don't understand what cases he's talking about.
I'm talking about Mr.
Mr. Heller, can you expand on that? Like, what cases is he talking about?
This is
When I
It's
ask,
not your
can I ask a
turn
point
to
of
ask
question?
him
Sure.
questions.
Go ahead, Mr. Duck.
The cases you're talking about, Myers?
Yeah, that's right, Kim Myers. I gotta put my reading glasses
Got
on.
it.
Yes, Kim Myers.
So prior to these cases, you never seen Mr. Bell as a pro se litigant up against the city law department?
No, I never did.
No. Okay.
I'll wait till you hear about
So,
that. That's gonna be cool.
Brief indulgence. Okay. Do you know John Coyle?
Yeah, I do.
In what capacity?
He used to be in our unit. He actually worked on a case with me when he first came aboard. I don't remember what year it was. I think he was with our unit for about 4 or 5 years before he moved on to the private sector. And he played on my softball team.
Yeah.
Very good baseball player.
And were you ever involved in a case with John Coyle that also involved Mr. Bell?
No, I was not involved in that case.
You know Michael Miller?
I do.
Okay, how do you know him?
He also used to be in our unit. He was one of the ones who clerked for Judge, the late Judge Pratt. And he was with our unit, let's say probably about 4 years as well, 4 or 5 years, and then he moved on to the U.S. Attorney's Office.
Right. Now, do you know, are you familiar with the cases? You said both of them were in your unit, correct?
They were, yes.
And were they counsel for the city law department in that Bell v. O'Connor?
I'm gonna object, I don't see the relevance of this.
Overruled.
The only thing I know is from what you served on me in the subpoena is that John Coyle was involved in the case. It doesn't say Bell v. O'Connor, but it was, Actually, I don't even see a caption here, so I don't know what case it was, but it's my understanding.
So, all right, I'll move on with this question. If they were on that Bell O'Connor case, that would have been while they were under your unit.
It wasn't my unit, I'm not the chief of the unit.
When you describe,
When I say my unit, I'm speaking familiar about, it's the unit I've been working in for 20 years, that's what I mean by that. I have never been the chief of the unit. I have been a divisional deputy, but that was for about 2 years, and I was really on the role of monitoring people's timesheets in that capacity, other than having my own caseload.
she's not monitoring their trial advocacy?
No,
You don't go to court with the,
no, that's not my responsibility.
well, outside?
I mean, I have always been available to all the younger attorneys if they wanted to, if they had questions about cases and what they should do, but that's as a mentor, if you will. But as far as assigning cases, overseeing the litigation, I've never had that function.
Do you remember when Coyle and Miller retaliated against Bell by lying?
Objection.
I didn't even catch that, I'm sorry. Do you remember when Coyle and Miller were?
Coyle and Miller retaliated against Mr. Bell by lying.
Objection.
Thank you.
I think, Mr. Duckett, you should rephrase that and maybe lay a foundation before you get to that.
Sure. Are you aware that Mr. Coyle made false statements against Mr. Bell?
Objection.
You're not.
Objection.
He already answered. He said no.
Can the witness refer to respondent?
They called the wrong lawyer. He doesn't know
If you can
anything.
quickly go to respondent exhibit 32. Sure.
Just give us all a minute.
They're gonna cut him
And
loose
that's
soon.
base number 641.
I'm going to object to this.
Well, let us pull up the document first and then we'll hear the objection.
She objects to you pulling up
What's
the
the number?
document.
641. 641.
Oh, this guy in the front has the red binder. Do they all have the red binder? Is that different?
You get a chance to review,
Well, hold on, there's an objection.
yeah.
What's the objection?
The objection is that this is totally irrelevant.
I think the red binder might be defense evidence. I don't know.
To these proceedings.
I'm guessing.
Well, Mr. Duckett, you
And,
wanna?
and Mr. Hubbard, why, his name is not mentioned in here, if I'm not mistaken.
Okay, well, I imagine that one of the first questions will be whether you've seen this, but Mr. Duckett, what's the relevance?
the relevance here is that my client is essentially saying that he has been treated as, has been the victim of disparate treatment, and I believe that
We're gonna hear why in a minute, guys.
it's come from the city's law department, Mr. Coyle being a member of that city's law department, and Mr. Hubbard being a senior in that law department, and especially one where he acknowledges Mr. Coyle and his unit. I believe that he would be aware of any proceedings that Mr. Coyle and Mr. Miller were a party to, and essentially that is what this document includes.
Well, I'll let you ask him if he's aware of it, but if he's not aware of it, we won't have any more questions about the document, so objection.
Okay, I'll first ask this, is this the same John Coyle that's in your unit?
I mean, who wasn't in the same unit as I? Yeah, I would say that's John.
And then this case is Aaron Bell versus the city of Philadelphia, correct?
That's what it says, yes.
Right. And then in this is an affidavit from that same Mr. Coyle, correct?
Apparently so.
Right.
Although I'm not familiar with John's signature, but I would assume that's his signature.
So In this particular, affidavit, have you seen this before?
No,
Never seen it?
until now.
Okay. So you agree that this affidavit is talking about the.
Objection.
We're gonna let the question finish, and then we'll hear the objection, but Mr. Hubbard, don't answer yet. Finish the question, Mr. Director.
So they are not allowed to ask any questions at all about another lawyer that he has, that the attorney has sued. They're not allowed to ask him at all. That's why they're jumping on it right away.
Would you agree that this affidavit, refers to the, if you look at paragraph 3, to the David O'Connor, case that we're talking about?
Objection.
Sustained.
Very well. When lawyers make representations to the court that they know are false, should they essentially notify the court?
Objection.
What's the relevance of asking this witness about that?
If he, just what the procedure would be when someone makes a mistake?
This witness is not equipped to, he's not an expert.
He's not an expert. So, sustained.
Thank you, I'll move forward. So, you said, Michael Miller was Judge Prater's law clerk, right?
Yes,
Okay, can you, refer to the exhibit, found in exhibit 37,
What's the page number?
692, page number 692?
all right.
Is this the same Michael Miller that's a member of the city, that was a member of the city's law department?
That is Mike Miller, yes.
So, in the matter that we just talked about, you're not familiar with Judge Prater's ruling on that?
Objection.
On what matter?
The affidavit that we just talked about?
Objection.
You can, so you're asking him, is he familiar with the Judge Prater's ruling
Right,
in that?
in the matter.
In the
Aaron
matter,
versus City
in that
of
case.
Philadelphia.
You can answer that question.
No,
He can answer that question, ma'am.
Now, was Michael Miller on, do you know if Michael Miller was on that case?
I do not know.
If he was on that case,
Are you a ghost?
do you know the judge that, you don't know the judge who was on that case?
No, I don't.
Now tell me, you said you first found out or was introduced to Mr. Bell with Miller's and Myers case, right?
Yes,
You were assigned to defend against that lawsuit, or did you assign yourself?
no, I was assigned the case. I
Who
was
assigned?
assigned it from the chief.
Got it.
And I think the chief then was, might have been Craig Straw before he went on to be U.S. magistrate judge, or it might have been Armando Brigandi, I'm not sure. Actually, no, he went from chief to being first deputy.
Okay, you told, this case was before Judge Andrews, right?
Which case?
Myers, Miller, Jarvis, Payton?
I don't think it was ever assigned to a judge. I think Judge Andrews might have been the team leader for those cases when we went to a case management conference.
Okay. So, who did you tell, you told Judge Andrews to put the case in arbitration?
I
right?
did not.
You did. So he didn't put the case in arbitration at your request?
I never made a request to a judge about that.
Okay. You made that request,
No, I made an opinion to the case manager that I thought those two cases, based on the amount of time in which the plaintiffs in those respective cases were detained, and based on the absence of any physical injury to either one of any of the plaintiffs. Actually, I think in Ken Myers there were 2 plaintiffs. And in Mr. Miller's case, it was just him. And when I go to a case management conference, when they ask me what the city's position is on something, sometimes I'll say what I said in those 2 cases, and that is like, well, frankly, I think this kind of case, it doesn't meet the major jury threshold. It's more of like an arbitration case. But that's not a request. It's just simply giving them my opinion, my experience opinion as an attorney.
The cases were eventually put in arbitration.
They were, and it was at the decision of the team leader.
Did
I
Judge?
never communicated with the team leader about that.
That's the question. You said you never communicated. Did Judge Anders hold a hearing or give Bell an opportunity to be heard prior to
I
putting the case in
never
arbitration?
discussed that with a judge.
So when you say never discussed it, was there, other than the complaint and the answer, case management memo, there was no discovery?
Well, by that time, I mean, in order to sit down with my clients to have them verify the answer, I did look at police paperwork, which was eventually turned over to Mr. Bell.
Right.
And that's where I got a lot of my information in terms of what I thought the value of the case might be. I mean, we're always asked to give a value to a case.
Right, my question is, was that information presented to the judge?
No,
No, right, okay. The arbitration statute, in and of itself, it prohibits a case, at least a case asking or demanding more than $50,000 to go to arbitration.
Objection.
I'm object to that as well.
Becca, here's a fact witness. That was his statement.
Prior to the outcome of these cases, you couldn't find any cases where an appellate court ruled that the trial judge can force arbitration in real estate cases.
I'm gonna object to that.
I didn't finish my question.
No, you didn't finish the question, so go
My
ahead.
apologies.
But I was having trouble hearing your question, so speak up a little bit.
I don't know, I'll start again. Prior to the outcome of these cases, you could not find any cases where an appellate court ruled that a trial judge can force arbitration in real estate cases or cases where the parties are seeking more than $50,000.
Objection.
Sustained.
When- Are you familiar with Hall v. Reed?
off the top of my head, no.
If you can refer to Exhibit 42?
Sure.
It's a page
What
number.
page is that?
1 second. 704.
704. You mean Hall versus Reeb?
Yes.
No, I'm not familiar with this case.
Would you agree that the ruling to put this case in arbitration benefited you?
Objection.
Overruled.
Benefited me personally?
City Law Department? Your part?
I don't see it as any particular benefit because
I pop up whenever I want to, Jude, so it's all good.
under the compulsory arbitration program, the losing party has the right to appeal and have a trial de novo. So no, I don't think it gives you any particular advantage.
Doesn't it cap how much that the plaintiff can receive?
In the arbitration, yes.
So wouldn't that be a benefit to the city's law department if?
Well, no, it would be a benefit to the city perhaps, but the city wouldn't be a party in the arbitration because the city's immune from intentional tort claims, which is what those cases involve. But as far as where the money comes from, yeah, I guess you could consider it being, and not necessarily an advantage, but a benefit to have a cap on what they'd be able to cover. Sure. But when it's a trial de novo, there's no cap.
when there's a trial.
Unless there's that agreement under the rules where they agree.
Not today, Bren. I made up my mind. I'm going to go into work. I'm going to keep my mouth shut. And I'm not going to pop off on anybody today. I'm going to go into work. I work a double. So I'm going to keep my mouth shut. I'm just going to do my job and come home. That's what I'm going to do today. I made up my mind.
To the medical records or something like that, and then there's like a cap on there, yes. But that's not the case here. There's no physical injuries involved in this case.
You, essentially, you asked the court to deny Bell's client's a jury trial because he told you in an email that black people were going to serve on his client's juries.
Objection.
Overruled.
Absolutely not.
He did tell you that in the email?
I don't remember exactly what he wrote in the email. He did say there was going to be a jury of 12 black men, something like that.
Can you,
I mean, the email speaks for itself. If you show me the email, I can tell you whether or not I saw that, because I do remember emails, there was some exchange about that, yes.
can you look at, responding exhibit 46, that's
Sure.
case number 793.
Which bait stamp number?
Starts on page 793.
I do remember this, and I did not oppose. And I don't think he actually filed a motion in spite of this.
In that email, you took offense to him saying that black people will serve on the jury.
Sorry, Mr. Duckett, speak up a little
I'm
bit.
sorry, in this email thread, in this email exchange, I refer you to page 805. You saying 805.
So what's your question about 805?
That he told you that black people were served on the jury, and you took offense to that.
I did not take offense to that.
Okay. All right. So, in that email, though, he didn't say 12 black men. He said a black jury would hear these cases, correct? That's his exact
Yes,
word.
that's what it says there. I agree.
All right. And essentially, when you pick juries on behalf of the law department, do you make it a matter to strike black jurors?
Absolutely not. Not for the basis of race. It's unconstitutional.
You friends with Nicholas Cummings?
Am I friends with him?
Yes.
I know Nick professionally. I don't socialize with him, but he and I have had cases together where he was a conflict counsel.
So it's strictly a professional relationship.
Yes.
What's his nationality?
Objection.
What he's trying to do and not getting there is to get this lawyer to tell him information he doesn't have on this case that he was barely involved in.
Going somewhere, Mr. Duckett, but overruled.
Or you mean his nationality?
Is he white?
He's a United
I'd
States
say is he
citizen.
Caucasian? Is he white?
Yeah, he's white.
Okay. What about Judge Shulman? You know her?
Objection.
Judge Shulman?
Schulman? No, I don't.
I don't understand the relevance of these questions,
Oh,
especially since Judge Schulman is not part of the case at all.
Definitely part of the defense.
I don't know Judge Schulman.
You familiar with the York v. Canaan matter?
No.
You weren't there?
The York v.
Canaan?
No. No, not
Bell
familiar.
was suing city police officers who your office represents, that case?
I'm not familiar with that case. It wasn't mine.
That's not one of the cases that Cummings was on and you,
Well, he might have been, yes. I mean, I don't know. Does it say he wasn't in the docket?
I'm asking you.
I don't know.
Objection, he asked and answered, he doesn't know this case.
I think you said that a couple of times.
Have you ever, asked Cummings to write a false complaint against Bell on behalf of the city?
Objection.
Ruled.
No.
If you didn't ask him, did you know he was intending to write a false complaint?
Objection.
Objection.
Sustained.
As an agent of the city of Philadelphia, you know that the city could possibly be liable in a 1983 federal civil action for your official conduct.
Objection.
Sorry, would you repeat that, Mr. Bell, and just speak up a little bit?
As an agent of the city of Philadelphia, you know that the city could possibly be held liable in a 1983 federal civil action for your official conduct.
Objection.
Wait, you're saying your official conduct? You're
Yes.
saying you're gonna have to lay a foundation before you can ask that. Sustained.
You didn't personally write any disciplinary complaints against Mr. Bell, did you?
That's correct.
None of your lawyers from your office filed any private disciplinary complaints against Bell, even though your office was the opposing party on all the cases that we're here about.
Objection.
Mr. Bell, all the cases that we're here about is too vague, so you rephrase that, please.
Every case that we're here for, the Millers.
See, that's what I like about this stream. So, most people go around every single day. What am I going to have for dinner? What am I going to have for dinner? Oh, God, what am I going to have for dinner? I don't have to do that. I just have to watch my stream, watch my chat. They always tell me what I'm going to have for dinner.
Case, the Myers case, the Murphy case. These were all cases where Mr. Bell represented clients against the city of Philadelphia. Correct?
I can only speak to the cases I represented, police officers and a detective, they're called. 2 police officers, yes, and a detective from the Philadelphia Police Department.
So, you didn't write the complaints. Nobody from your law department wrote the complaints, but y'all did use your influence to have third parties write complaints for you.
Objection.
Sustained. If you want to get to that, Mr. Tucker, you're gonna have to lay a foundation.
You familiar with Jarvis Payton?
I think he was one of the plaintiffs, within the Myers case, as I recall.
Yeah.
He was the one, I think, operating the vehicle. That was pulled up. But it
And,
was Miss Myers' car.
right. And did you come to learn that Jarvis Payton's history with Judge Anders prior to?
I have no idea about Mr. Payton's history with other judges.
What's your relationship with Judge Anders?
I'm an attorney, he's a judge, that's it.
Nothing more than that?
Nothing more than that.
You had connections with lawyers who work for the ODC?
Who?
Do you have
Objection.
connections with lawyers that work for the ODC?
No.
Overruled.
Who is Eric Organ?
Eric Ordick. I think he's an ACS with our unit, not our unit in the law department, but I'm not sure he's there anymore. The only thing I know about Eric is that he was on my softball team last year.
And that was, so was, if you remember, was Eric Orbick did he do the case management conference for Miller's and Meyer cases?
No, I don't think, why would he do that? No.
Do you remember who?
You mean, was he the case manager?
You remember
I
the
don't
case
remember,
manager was?
I don't remember who the case manager was, no.
The guy being questioned is a lawyer. He was part of a case in the 80s. Before Aaron Bell was a lawyer, he was part of a case in the 80s where Aaron Bell sued the city. And we're going to hear more about that. This guy, okay, because of that case in the 80s, Aaron Bell, the lawyer in trouble right now, is saying that all these cases that he's losing as he's practicing as an attorney now is because of this case in the 80s. All right, this guy was a part of that in the 80s. We're going to hear all about it as soon as he's off the stand and Aaron Bell comes back up.
May I present what Ms. Ammons presented to the witnesses yesterday, the case management?
Well, this was the first day I presented this.
Yes. And yes.
Okay, and here it is.
Go ahead, Mr. Tucker.
Okay.
Oh, that's your copy.
Yeah, yeah.
Okay.
Are you familiar with that document?
No,
If you make,
I've never seen a case management conference report from a case manager. Never seen one.
do you recognize the parties?
That's Ken Meyer's case versus the Romita. There was 2 police officers.
So that's the case that you represented the city on, correct?
I represented the officers.
Officers,
The
okay.
city wasn't named.
And your name is on that report, correct?
That's correct, yeah.
Mr. Bell's name is on that report,
That's correct.
And Eric Orvick's name is on that report, correct?
Yes,
So he was the case manager.
apparently so. But
Okay.
he wasn't, if he was a case manager, he wasn't working in the law department.
Exactly.
He was an employee, but I guess subsequent to this, he applied for a position with the city.
So after he worked on this case with Judge Anders, he got a job with the city's law department.
I don't know.
That's not what you just said?
I mean, I don't know the way you phrased it. I don't know what went on, what led to him applying for the job.
I'm not asking you that, I'm just asking sequence of events.
If that's how it went, then that's how it went. But I don't know personally how it went.
He didn't work with the city's law department prior to being the case manager for this case, correct?
I don't know. My relationship with Eric Orvick is, he was on my softball team.
And he worked for the city law department, you just said that.
Well, he had to if he's gonna play on the deep pocket softball team.
And he still plays on that softball team?
No,
Okay. So after he left the law department?
I don't know.
Okay. So right now, he's not working with Gloria Ammons?
I don't know where Eric Orvick works right now.
You don't know if he works with the ODC?
Objection.
I don't know.
Okay. Do you know any other
Hold
current?
on. This,
Hijinks is like shenanigans, only for younger people.
when we have objections, Mr. Hubbard, just pause before you
Sure.
answer. I'll overrule the objection.
Do you know any other current employees of ODC?
No,
How do you know Eduardo Rubino?
Judge Rubino, he's retired now. First time I appeared before Judge Rubino was when I was at the Philadelphia Housing Authority. And I've appeared in front of Judge Rubino probably about 10 cases over my 40 years of being an attorney.
Outside of the professional capacity, do you have interactions with him any other way?
No, I have no interactions with him any other way.
Has your office hired any of Judge Rubino's former law clerks?
I don't know, I'm not sure.
How do you know Judge Stacy Wallace?
I have no idea who Judge Stacy Wallace is.
So you didn't donate to her campaign?
I'm sorry.
What?
So you did not donate to her campaign?
I don't donate to campaigns, period.
Do you have any, family who works in the judiciary?
No.
What's your relationship with Francis Healy?
He has been the civil rights, actually not just the civil rights unit liaison, just the other litigation units liaison with the police department. And I've known him in that capacity since he was a captain. He's now a deputy commissioner.
And how long has that relationship been?
I think it's been, for me, the 20 years that I've worked in the civil rights unit, he's always been the head liaison for obtaining records for discovery and lawsuits involving the police department.
So it's safe to say he's heavily involved with the cases against the Philadelphia Police Department.
Heavily involved? I wouldn't say that, because that suggests that he's testifying all the time. I can't say how heavily involved he is. I only know how.
I wonder how many cases the Philadelphia Police Department has against them right now.
Involved he is with respect to my cases.
Significantly involved.
I wouldn't say significantly involved. He's a conduit, if you will.
Did you ask Francis Healy to intervene in the Murphy case?
I don't know what the Murphy case is.
I have nothing further.
Salmon?
Yes, Mr. Hubbard, you recall the Miller and Myers case, correct?
Yes,
Okay, you were the attorney representing the officers in those two cases?
that's correct.
Okay. Now, in regards to the Miller matter, there was a pre-conference, or I'm sorry, let's strike that. There was a case management conference
Yes,
that happened in that case sometime in February 2020. Do you recall that?
I don't know the exact
Okay.
date, but there was a case management conference.
As part of a case management, are you required to file anything before the case management actually occurs? Do you recall
And
that?
this is outside the scope of our.
He talked about the case management?
All right, I just looked it up and I could see 58 lawsuits against them right now. But that's not like a solid, this is the exact number.
I think it's within the scope.
Yes, you're required to file a case management conference memo.
Okay. And do you know how many days before the case management conference that you have to file that
I
management?
should know, I think it's at least 15 days before the conference.
Okay. And in the
Life
Miller
does
case,
do
do you
that.
recall if you filed your case management memorandum?
I'm pretty sure I did.
I'm gonna show you a copy. No, I didn't give you that. I probably let you see it in the other two hearings. Does this look familiar? Oh, sorry, Josh, I didn't say it.
That's all right.
I'll show you. I forgot he was over there.
You're not used to me sitting here.
I am not.
Yes.
Okay. Do you recall what happened in this case management conference? Based on,
In what respect?
in what respect of how, what occurred during it? Were questions asked by the case manager? Did you give your opinion about what the case was worth?
Yes.
Okay, and do you recall exactly what you said to?
I don't recall exactly what I said, but I know that I made the comment or opine that this case appears to be below the arbitration limit. I mean, those aren't my exact words.
Okay,
And that's it, as far as the value of the case would be.
okay. And do you recall, if Mr. Bell put his input in how much this case was worth?
I don't recall what Mr. Bell said, but they always ask plaintiff's counsel and defense counsel first to tell them about the case, and also, you know, when you get to damages or whether or not there's been any settlement negotiations, people will say what they think the cases are worth.
And after do you recall how long this case management conference lasted?
They don't last very long. They're probably about 15 minutes, not tops.
And after the case management conference was done, what normally happens, to your knowledge?
They normally give you tell you what track you're going to be on. Like there's a standard track, there's an expedited track, and there's a protracted track.
Okay.
And that's what they tell you. And then eventually what comes from out of that is a case management order is put on the docket and you're served it electronically.
Okay. Now, just to,
But in this case, the court
in Miller,
remanded it to arbitration.
okay,
So we didn't get a case management.
okay. And did you encourage Judge Anders to put this case, the Miller case, in arbitration?
I did not.
Did you have any contact with Judge Anders whatsoever before he entered his order placing this in arbitration?
I did not.
Do you normally have any contact with judges after a case management conference?
I do not.
Just so we can be well-rounded here. This is the Kim Myers. Forgot Josh.
I think Beck is in Perth. Throw the goat might be in Perth, but I'm
Can you
not.
identify
I don't
this?
remember now.
This appears to be my case management conference memorandum in the Kim Myers case.
Okay, by the way, what date was that filed?
It was filed on the 21st of January, 2020.
Okay. And I'm gonna give you back the Miller case so you can
Sure.
identify when this was filed.
Of January, 2020, 2 minutes before the Myers
Okay.
form was filed.
And in the Myers case, you also, in your memorandum, you recommended that this was a arbitration case, or that the amount in controversy was below 50,000?
I didn't put it in the memo.
Okay.
Throw the goat
That-
is what her name
That's something
is.
I said during the conference.
During the
with my
conference,
case
okay.
manager.
And did the case management conference for Miller and Myers, did it occur at the same time? Do you recall?
That I don't recall.
Okay. Again, did you, after you put in your input about what the case was worth and where it should go, did Mr. Bell have opportunity to discuss what he wanted to happen in this case?
Yes,
Okay. And did Mr. Bell get equal opportunity to address where this case should go? He was not cut off or anything, correct?
you had an equal opportunity.
Okay.
Yes.
Now, after, do you know what if this case was transferred to arbitration?
That one was.
Okay. And after the case management conference, did you have any contact with Judge Anders?
I did not.
Did you encourage Judge Anders to place this in arbitration?
I did not.
Okay. Do you normally encourage judges to place cases in arbitration?
Never.
I have no further questions.
Yes, Briefly, did you tell Eric Orvik that tell Anders Hubbard said put these cases in arbitration?
No.
You just was shown 2 case management memorandums that you prepared. You'd agree that in preparation, you had to review the complaints?
Yes.
Right. And if you look at page 2 of both of those case management memoranda, there's a line item that says demand.
Yes.
And on both of those, you put the demand is in excess of $50,000.
Yes, that was in the wherefore clause of the complaint.
Now, temporally, do you remember, immediately after the case management conference, wasn't this case scheduled for a jury trial? And then later changed to arbitration?
That could be the case, sure, yeah.
And as far as you know, it's not the case management memo, it's the complaint that essentially controls the case.
Objection.
Overruled.
You're asking me, does the complaint control the case?
So, essentially,
Now I'm gonna object to this because this was not covered on cross. This is outside the scope.
I'm talking about the comparison between the case management memo and the complaint.
Now, your cross-examination centered on this case management conference, so I think it's fair, but try to ask more precise questions.
Now, with regard to court filings, the position of the case, whether it's going to jury trial, arbitration, wherever position of the case, that's controlled by the complaint of the case and not the case management memo.
It goes beyond that.
But there's an objection by Mr. Byrne.
Overruled, you can answer.
I think it goes beyond that. The rules of civil procedure govern how a case proceeds, not just the complaint. The complaint, as you know, initiates the action. And whether it's more controlling than a conference memo in terms of the litigation, I would agree, because that's a pleading. The case management conference memo is not a pleading, but the answer is a pleading, and it too has an important part in the process. But as far as a judge's authority to remand a matter to arbitration,
Objection.
that's in the rules of civil procedure.
Let him finish his answer.
I finished it.
Okay.
Nothing further.
I have one quick question. Mr. Hubbard, can you explain what happens when a judge, you said a judge just now in response to Mr. Duckett's question about a judge remanding, you said the rules say he can remand or something like, I don't want to put words in your mouth. Can you further explain that answer?
The judge
I
has,
object to any, I have objection
Open the door.
to your question.
Yeah, maybe, I had a little trouble following your question. So.
Okay, I was asking him to explain further because Mr. Duckett cut him off.
I asked him if he finished his answer, he said he did.
Okay, I have no further questions.
All right, Mr. Hubbard, any questions?
I do not.
Questions? I don't have any questions either. Thank you very much. We
Thank you.
appreciate
Thank you, Mr. Hubbard. Thank you, Mr. Byrne.
it. Vern, thank you.
Thank you.
Unplug that. It's a pleasure seeing you.
Good to see you.
Okay, here we go.
Can we take our first 10-minute break?
Yeah, we can. Let's take a 10-minute break.
All right, thank you.
Yes, I'll
Aaron
see you on
Bell's
the other
getting back on
side.
the stand. And we're gonna learn a lot.
Yeah.
Just let us know when we're good to go, Sarah.
We're good.
Okay,
We're live.
thank you.
Thanks. Before we get to the next witness, Mr. Duckett, I just wanted to check to see if you've had a chance to look at this letter that ODC provided and just ask whether it changes your plans at all about this afternoon or you still want to proceed.
Still want to proceed. I had a chance to review the letter.
I thought you might say that. So hopefully, though, this will streamline the examination somewhat. Okay. Call your next witness.
Call Aaron Bell to the stand.
I don't know, like 1%. Let me pull up the number. Hold on. Maybe it's up to 3%.
Mr. Bell sworn in yesterday, so you're still under. Yes. Do you agree with that, Sam?
Was he sworn in yesterday? He was? Okay, I missed that part. Okay, thank you.
Okay. And before we begin, just to remind you about my ruling from yesterday. If you intend to elicit any testimony about other complaints, or Mr. Bell, if you intend to say anything about other complaints that you filed against other lawyers, then we need to pause and we need to go off the live stream before that happens. So make sure that you give some notice of that.
Can we address how we intend to, address those issues prior to?
I think you can just say, in this, my next question is going to concern
Kristen.
the
Hi, Mel.
topic that we talked about, and then I'll stop and we'll go off the live stream, and then that portion of the transcript will be confidential. You don't have to get into exactly what you're going to say, but just enough so that we know we have to go off the live stream.
It was our intention not to talk about anything that would involve 402.
Okay.
But we do plan.
No, 1.2% of my viewers is Australia. 71% is the United States. Canada, 2.5%. United Kingdom, 2. Australia, 1.2. And then it's just like Germany, 0.01. It all goes down from there. I understand that doesn't add up to 100.
To address some of the activity in context of what happened, but nothing about any complaints.
Okay. Well, if you're not going to get into any complaints, then we're not going to have to go off live stream. But I just wanted to remind everybody that, under no circumstances are we going to refer to 402 material on the live
With the
stream.
exception of how it applies to Mr. Bell.
Mr. Bell has waived any 402 considerations.
Agreed.
Okay.
Morning, Mr. Bell.
Morning, Mr. Duckett.
Can you tell us about yourself?
Yes, I'm a civil rights lawyer. I've been a lawyer for 8 years. I do criminal, in addition to civil rights, I do criminal defense, post-conviction, state post-conviction matters, including some federal matters. And then I do on a smaller scale, like real estate and commercial stuff. I graduated from Temple University for my undergrad, and I went to Widener. I graduated from Widener, Delaware, but I started off at Widener, Harrisburg. And before law school and before I graduated law school, I did some real estate work. I worked as a paralegal and property management. And I'm a Philadelphia native.
Awesome. Well, you talked about your trial experience. Is that limited to just the trial courts? You do appeals?
I think I said that, yeah.
Okay. What made you decide to pursue a career in law?
Well, when I was little, the idea of being a lawyer, I entertained it. I wanted to be a lawyer for a long time, but it didn't really, the idea didn't really put the hooks in me, I guess, until I had a bad experience. I was stopped and frisked by Philadelphia police pursuant to Mayor Nutter's, former Mayor Nutter's aggressive stop and frisk policy. I was in college. I think I was maybe a junior. I think I was a junior in college. I encountered 2 Philadelphia police officers, and they illegally stopped me, searched me, arrested me, and they wrote false reports to justify their conduct. Ultimately, I sued the city and the officers in their official and their individual capacities in 1983 in the Eastern District of Pennsylvania, and I represented myself. I had to teach myself the law because I wasn't a lawyer. I had paralegal training, but it was nothing like a federal lawsuit. And a 1983 lawsuit was nothing, that could prepare me to deal with that situation. So I taught myself the law. And
I thought it was in the 80s. It was early 90s. My bad. So he got frisked while he was in college. Not a lawyer. Not even in law school. just in college, general studies. And then he sued the police department, and he sued the police officers, like, individually. So he sued them all.
Situation
And he was pro se.
really motivated me to want to be a lawyer. Well, I guess I wanted to be like a private attorney general to protect the Constitution as much as I could. I wanted to contribute to that. And that situation just put a fire under me. And it motivated me just to do civil rights. So that's why I'm here.
What was the name of that case? You said you had a case that involved you being the legally stopped first.
Yeah.
What was the name of that case?
It was L versus O'Connor.
Okay. And was the city law department the defendants, or did they represent the defense?
Yeah, the city law department weren't defendants. They were, for that case, they just defended the case. The case was with John Coyle, Aaron Shatlin, and that's how I got introduced to Hubbard too. Yeah, I know Mr. Hubbard, he don't remember, I remember. We got a story. I guess, you can say don't remember, but he was certainly there. He was supervising them. They were newer lawyers. So he was there. That's how I got first introduced to Mr. Hubbard.
When you said he was there, was he involved in any of the settlement negotiations? Did
He was there with the verdict. Aaron Shatlin and John Coyle, it was their case. But Hubbard was a senior lawyer. So, towards the end of, because in civil litigation, everything's paper. There's really no court appearances until you actually have to argue a motion. It's not like criminal court. You're never in court usually, But there are times that the pretrial conference and the verdict and the trial, that's when I encountered Mr. Hubbard. It was Mr. Hubbard there. I think it was other members from the law department.
Got it. What kind of damages? Well, one, what was the outcome of that?
I prevailed. The jury entered a 6-figure verdict, and it was all emotional distress.
He won 6 figures in that case before he was even a lawyer.
The officers didn't beat me or anything. They made false statements and arrested me, and I didn't have emotional distress. That's not required though. And it was a 6-figure verdict based on that alone.
Now, in that 6-figure verdict, did you receive any comments, or did you have, what was the position of the law department after?
I'm going to object to this. I don't see the relevance of this questioning.
Well, first we have to let Mr. Duck finish his
Oh, it's
question.
relevant.
Then Mr. Bell, let's allow Ms. Ammons to make the objection and go ahead, Mr. Duck.
So, what was the position, or what was the reaction from Mr. Coyle, Mr. Shatlin, Mr. Hubbard after you got the verdict?
Objection. The relevance. And if he's going to talk about what they said, that's hearsay.
I didn't ask what they said.
Well, we'll deal with that objection if and when you make it.
What's the question? Sorry.
Did you have interaction with them after they gave you the verdict with the city's law department?
I mean, yeah, they were in the court because they were physically there. So yes, I had interact. I'm not trying to be smart with you, but yes.
All right. And then,
I'm sorry. So, yes, after the verdict, they were upset. And I wanted to shake Mr. Coyle's hand. I was happy. I won. And, I didn't, I thought that's sportsmanship. They didn't want to shake my hand. And when I was leaving, Mr. Coyle, he said that it's
Objection as to what he said.
Mr. Duck, do you have a hearsay exception in mind?
I would say that in this particular case, it would be a party opponent. The city law department.
No, it's not party opponent. It's not party opponent, but I I'd say it goes to,
Effect on listening.
yeah, it goes, exactly, it goes to his state of mind, and Ms. Ammons, you put in issue what Mr. Bell was thinking when he made certain statements, and all of this goes to that. So that's overruled. It's not being offered for the truth of the matter asserted. It's being offered for its impact on Mr. Bell and his state of mind.
Yes, he made this statement. He didn't want to shake my hand, and he told me this ain't over. And he stated that we'll deal with you. And when he said this ain't over, I'm figuring, all right, you're just gonna appeal. Well, this ain't over, and we'll deal with you. We'll deal with it. Okay, and I left. He took it like a sore loser though. And Mr. Hubbard wanted me to settle the case for $2,000. So when we was waiting on the verdict, it was me, Coyle, Shatlin, Mr. Hubbard, and they had law department lawyers in the back, and they had some students from Penn observing the trial. And I think Mr. Straw was there. This is before he became a magistrate. And I think he said, yeah, why don't you just settle the case? Hubbard wanted me to take $2,000. I said, no. The jury came back and looked in my favor.
Can you refer to Respondent Exhibit 29? Case number 621. 621.
I'm here.
What is Exhibit 29?
This was the civil judgment form in the civil case that we're talking about. He didn't say the amount on this one. I've seen another one that has the amount, but this is the form. It's saying that I got the judgment against the listed officers. I'm sorry, am I speaking too low? All right, yeah, I'm sorry.
Now, you said that case was for, you want for emotional distress?
I'm going to object to the leading questions.
I'm asking what you said prior.
Yeah, that's just foundational. You could
Headway,
dial
thank
back
you
the
so
objections a little
much.
bit.
Thank you, Headway.
Yes, it was just for emotional distress. And the city had filed motions for remitter, trying to reduce the amount. The judge ruled against some on those. So I did collect the judgment only for emotional distress.
Now, how would you define emotional stress and psychological trauma? Are they similar?
I mean, I would think emotional distress, psychological trauma would have to be emotional distress. It's a form thereof because it's not like physical. Nobody got their hands chopped off or something like that. So it's just all in the mind.
So your claim was absent of lost wages and medical, like no medical injuries, nothing like that?
Yeah, I mean, because the law say you don't have to have medical injury to get damages. You can have a jury trial with the federal. You got the 7th Amendment. You can have a trial for $20. Like, I mean, yeah, no. To answer your question, there wasn't any physical injury. I didn't present the court out. I didn't say I lost money from at work, which I actually did, but it just wasn't substantial enough to put in the lawsuit. I didn't think, and plus I was in school at the time, and I was working part-time. And it just wouldn't have been appropriate. I didn't think it was worth it. I had emotional distress based on what happened to me and the officer's conduct. I even got punitive damages from that too. Because punitive damages, that's in addition to actual emotional compensatory damages. That's a whole different category. You can get a lot of money in punitive damages as long as the court complies with BMW versus Gore.
So with that said, the plaintiffs in Millers and Myers, were they similarly situated?
I don't understand the question. I'm sorry.
In this particular Bell versus O'Connor case, you said you won for emotional distress. There was no lost wages. There were no medical records. There was no other claims made other than emotional distress. Were the plaintiffs in Millers and Myers similarly situated?
Mr. Duckett, I'm sorry. All right, so we're talking about Bell versus Connor, right? And now we're talking about, when you say similarly situated, can you, I'm not trying to be smart, but Similarly situated in what? You gotta be a little more specific as far as like we're American citizens, they're like black people, what specifically are you talking about? And I'm not trying to be rude, sorry.
Understood. Do you remember the case management conference memorandum that you essentially filed in the case?
Yes, I remember the case management conference. I remember Mrs. Ammons producing me with the documents that were submitted concerning that matter. Yes, I recall that.
And I guess my question is that you indicated that their claim was for psychological trauma, right?
Yes, I did.
And I'm saying that they were sent, and their claim was absent of lost wages, as Ms. Ammons went through the list, absent of medical damages, future earnings, etc. It was just psychological trauma.
That is accurate.
And that's what I'm saying. Is that similarly situated to your claim with just emotional distress?
All right.
I know you said dial back the objections, but this is speculation on this. Speculation, if theirs is the same as Mr. Bell's.
Well, I think, I would say.
It's not
it's
speculation.
It's overruled, but I don't think these questions are particularly precise, Mr. Dunn.
I'll move forward.
It's exactly precise. Are both of your cases based only on emotional damage? Yes, they are.
In that lawsuit, you said you sued the city without having a lawyer. I'm sorry, so in that case, you weren't represented, correct?
And when you say that case, I'm
David
assuming you're
Bell
talking
versus
to.
O'Connor?
Yeah, this is a civil case. I know what you're referring to.
Right.
Yeah, that wasn't, yes, I was trying to find a good fit. Talked to a lot of lawyers and just wasn't a good fit. But I did, so I ended up litigating the case until we got to the summary judgment stage. Judge Stuart Dozell was on that case at the time. And then once he denied the city's motion for summary judgment, he recommended that Paul Messon and Radowski take over the case because they were already handling the class action on the aggressive stop and frisk policy, which my case was actually a part of that, but I didn't want to participate in the class action. And they were on the case for a couple months, but unfortunately we disagreed on strategy, and they requested the judge to withdraw. We all agreed, and the judge allowed them to withdraw. The city was at the hearing. However, Judge Dozell listed in his withdrawal order, by mistake, it was a typo. He wrote down a crime fraud exception. Paul Messon never asked if you withdrew from the case because any crime or fraud. We just disagreed on strategy, and the transcripts and everything proved that the city seen that. And after that, we had a trial. Nobody mentioned anything about no crime, fraud, or anything like that, because it was clear that none of that occurred. And we had the trial, and I won the judgment.
You said you won the judgment. The comments that were made by, you said you had comments by John Coyle. The comment was, it's not over yet. How did you take that comment?
At the time, I thought that was, so when he said this ain't over yet, so there's two comments. This ain't over, he didn't want to shake my hand. But then, we'll deal with you. I mean, just right after he lost the verdict to a pro se litigant. So, I mean, of course, he's probably, upset. And then people was in the back, the students was in the back. And it's all of them against me. So at that time, I didn't think that he was just upset with the case, whatever he lost. I mean, we all lost. At that time, I didn't think nothing of it. Until, later on.
Who is Jarvis Payton?
Okay. He's a litigant. All right, so Jarvis's guy, he had a case with Anders. So after I met Jarvis Payton after the case was published. All right, so there's a lot going on here. Let me explain. All right, so once I won the verdict, it was published in the news, and I did not know. I found out because people were reaching out to me. Some of my family members reached out. I never talked to a reporter. They reported it, the story, and then after they reported it, but after they reported it, Jarvis Payton reached out to me. That's right. He reached out to me. I think it wasn't him directly. It was either his brother or his mom. And they told me that they had a relative who dealt with the same police officer that I did, and they asked me if I could testify in his defense. And they asked for information that I had concerning the civil case, and can I give them documents? And I eventually talked to Peyton and talked to his family, and I seen what was going on. He had the same officer on his case. It was the same story, pulling people over, fabricating a basis to justify his actions and testifying for that in court. And I said, yeah, I will testify for Mr. Payton. And I did come forward to the court to testify. And that's when well, go ahead, you got your question. I hope I answered your question. Not really.
Yeah, I just wanted to know who he was. Now, what if anything happened when you came forward in this case?
So I alerted the court that I'm an available witness, and I'd like to testify, let the court know. I wrote an affidavit for Jarvis, actually. He gave it to. I'm sorry. Yeah, I wrote an affidavit to Mr. Payton. He gave it to the judge. And,
Just a little bit, Mr. Bell.
slow down.
Speak up just a little.
Oh, I'm sorry. I'm so sorry. And I just came forward to the court and I wanted to be a witness. Well, actually, I didn't want to be a witness. I felt like I had to be because I experienced these same officers with me, and Jarvis' case was kind of similar. And Judge Anders wouldn't allow me to testify on behalf of Mr. Payton.
Do you believe that?
I mean, it sounds like he doesn't know Mr. Payton at all. He wasn't a witness to the event. He doesn't know anything about the event. I don't know. I don't see how that gets in. I just don't see it.
Anders misapplied the law?
Objection. I don't see the relevance of this.
Yeah,
No, I don't.
overruled.
Yes, yes, the rule. So, all right. So in a criminal case, all right. So if you got newly discovered evidence that you discovered that you could not reasonably discover before your appeal or before your conviction, you have to present it at the earliest time. And at the time that the news media was reporting the case, the verdict in the civil case, Jarvis, he wasn't technically convicted. Judge Anders found him guilty after a bench trial. Jarvis fired his lawyers and he was proceeding pro se. And at this point, before the sentencing, he found out about the case that I had the same officers testifying. He had to present his issues before he got sentenced, did not waive it. And he couldn't blame anybody else because he was representing himself as he fired his lawyer. And Judge Anders at the time, he explained that his belief was that Mr. Payton had to file a PCRA petition after the direct appeal process was over. But the law doesn't work like that because PCRA in this particular instance, in fact, he would have waived his issues because you claim ineffective assistance to counsel on PCRA.
You claim what?
Ineffective assistance to counsel. And that's saying your lawyer or whoever represented you during the trial and the direct appeal phase were ineffective for any actions or omissions. In this case, Jarvis Payton was representing himself, so he couldn't argue that. It was his duty to present the claim when he found it on direct appeal. Judge Anders wanted Mr. Payton to argue his newly discovered evidence claim on PCRA. And then he also was saying that it wasn't, he didn't meet the requirements of newly discovered evidence just with a news article. But this situation was more than somebody just found a news article. I actually came forward to the court. So when you say, did Judge Anders make a ruling that wasn't correct? Yes, he did. Because he said that Mr. Payton's claim was not right or he said it was meritorious. It didn't have merit. It was meritless.
So you mentioned PCRA. What does that stand for?
It's the Pennsylvania Post-Conviction Relief Act. That's what it stands for. It's the state version of the 2254 federal habeas corpus. And it's not an appeal. People think PCRA is an appeal. It's actually not, but that's another story for another day.
Did Mr. Payton file a PCRA or an appeal?
He filed a direct appeal. When Judge Andrews denied Mr. Payton's motion to produce me as a witness to testify before he got sentenced to avoid the need to be sentenced, Mr. Payton, he appealed the case pro se.
Can you refer to Exhibit 30, please, which is page number 623?
Yeah. Okay, maybe they're orange and not red. They look red sometimes, they look orange other times. But yeah, the little red and orange binders, that's the defense's exhibits. And all those black binders are the Bulldogs.
Tell us about Exhibit 30.
Well, this appears to be the opinion that was issued in Jarvis' case. It was in 2015. I know what it is. I haven't read it. I know what it is, but I haven't read it. And the court in here, they explain, because Jarvis argued, I think he argued more, he did argue more than one issue. He argued sufficiency of the evidence issue and the newly discovered evidence issue. And the court affirmed the sufficiency of the evidence rulings, and it reversed Judge Andrews on his decision to deny Mr. Payton hearing. So in this opinion, the court ordered they reversed it and sent it back to Andrews to hold the hearing and explain that if I testify according to the federal testimony, to grant a new trial.
Okay, so after the Superior Court overturned Judge Andrews, what happened, if anything, when the case was sent back to Andrews on remand?
Okay, so the date on this opinion does say June 17, 2015, and it usually takes the courts about 30 days from their decision for the record to be reviewed. But we didn't have the hearing until 2 years later. I remember that. So the hearing we had was, the Judge Andrews did schedule a hearing. It was sometime in 2017. And I testified for Mr. Payton, explained what happened. And Judge Andrews did not appear to be, it didn't seem like he was happy that I was testifying. He didn't say anything. It's just that his demeanor and the attitude, and he did yell at me one time, and I don't want to I don't want to be like a crybaby, but it was just a little, there's a little off-putting. It was something with an exhibit, I forgot what it was. His demeanor didn't appear, the eye raised, I remember that. And so I testified, and then Judge Andrews granted the relief, and when me and Jarvis's mother was leaving the courtroom, I was not on the stand, we were leaving out, and he stated to the district attorney that I would never rule in their favor. My hands were tied. That's the last thing I remember from Judge Andrews when he said that. And I was outraged by that. I was outraged. I was like, wow. He said that to me, and Jarvis's mother heard that too. I remember that.
Did this case get media attention?
Yes, it did. It got media attention. It did. It was reported. I seen multiple stories. I seen something online about it because they kept. All right, so the officers was involved in a couple cases, so I kept coming up with people's cases, man. It was but anyways, this did. Yes, this did.
Can you look at Mr. Marcus, Exhibit 31?
What page?
637. Page number.
I am going to object to to Exhibit 31. This is a newspaper article.
Yeah, I was adjusting things.
It's not firsthand knowledge by the witness. This is hearsay, a newspaper article.
Not offering for the truth of the matter.
Okay.
let's hear what the questions are.
I'm there.
I asked you, did this case get media attention? What is Exhibit 31?
This is a newspaper article that was written about me. And after it was written, the lady who wrote it, Miss Julie Shaw, she reached me after. And yeah, this is the article. This is one of them.
And this has to do with you and Peyton?
Yes, yes. She in here she just summarized the facts. Yes.
And then, what newspaper outlet produced that article?
I'm sorry, what?
Who is the author? What
Company? It says the Philadelphia Inquirer right there.
Okay. After the media published a story about you helping Peyton, what if anything did the Philadelphia Law Department do?
They published a false, after this, this was shortly after this. I don't remember the specific date, but they published it was in 2017. At this time, I'm not a lawyer. I think, I was in law school actually. Mm-hmm. Yes, I was. And after this incident, because other people were contacting me about these same officers. Anyways, the city of Philadelphia Law Department published this false report saying that I asked Paul Messin to commit a felony, and they were using Judge Dozell, Stuart Dozell. Judge Dozell had retired at the time, and they were using that typo when they knew it was a typo, to retaliate against me. They were saying that Paul Messin I asked Paul Messin to commit a crime, and they knew the typo was wrong.
So
Yeah, I remember that. Yeah, that was after this.
So, just so we're clear, Paul Messin was the original counsel for the Bell versus O'Connor case?
Yeah, and this is, I don't want to confuse everybody with this long saga. It's just, all right, so that case was my case. I did it pro se. But right after Judge Dozell denied the city's motions for summary judgment, he recommended that I have Paul Messin and Radowski. I mean, they are the best lawyers in this area of civil rights, and I agree. But we disagreed on just trial strategy. And they're way more refined than me. Like, this Paul Messin. And I think if they did it, they probably would have won more money. But to answer your question, they were on the case just for like maybe even a month and a half, maybe two, I don't recall. It was just a strategy disagreement, and the law department was at the hearing, and we got transcripts and everything. They know, that's why nobody said crime fraud, even though the judge made a typo. So
can you refer to Exhibit 32?
what's the page? I mean, there ain't no tabs on it.
Page number 641.
I'm sorry, you got a question?
Right.
I'm gonna object to this. This is the same objection we had for the last witness.
No, the last witness said he didn't remember this case or recognize the affidavit. Mr. Duffy hasn't had a chance to ask Mr. Bell about it, but I'm sure that he has seen it. Examines, we have to let Mr. Bell put on his case.
Okay.
What is Exhibit 32?
This is the false statement the law department submitted accusing me of serious misconduct. So basically, this is,
Can I ask who was the author?
it's John Coy. At this time, he's at the school district. He was assistant general counsel for the school district. Because after the O'Connor case, he got a job with the school district.
And then prior to him writing this affidavit, what was your connection or relation to Mr. Corbin?
Like my connection?
Were you on cases before? Was he opposing counsel?
Yeah, it was him, Stratland, and as I said, how Hubbard be lurking around. Obviously, we'll talk about that, but and when I left after the verdict, he was upset about it. He didn't want to shake my hand. He took the verdict so personally. So when he told me that it's not over and we'll deal with you. I'm thinking like he did, that was a subtle threat. It's not over, we're gonna appeal. I know you're gonna appeal, but that's that. I didn't like that comment. But I didn't think of nothing until this.
Got it. And this essentially, when you received this, it's your testimony that you said this was false.
This is he made up a whole version of events. He swore under the penalty of perjury that Paul Messon got off the case because I asked him to basically commit a felony. And I'm summarizing. I don't think he even used the word felony, but when you read this is really vicious. And he stated that he was at the hearing. John Coyle wasn't even at the hearing of withdrawal. Christopher Ryder was. And so him making this up, this whole story, it was, I was shocked. I was very shocked by it. It was very, I'm sorry, I had to report this to the bar, but go ahead.
So what happened next?
Hold on. Let's go off the live stream.
Give us just 1 second, please. And just a reminder, Mr. Bell,
He's not allowed to talk about what other attorneys did or said.
you're a fast talker, and so just for Kim's sake, if you could just slow down just a little bit, I think she'd greatly appreciate that. Sarah, we can go back live. Just please confirm when we are live. Thank you.
Yes, ma'am, we are live.
All right, Mr. Bell, just
Yes,
you
yes.
want to clarify your statement.
Yes, absolutely. So when I say reported it to the bar, I meant the Board of Law Examiners. Because at this time I had I had my bar admission application pending. And as you know, they want you to they want to know everything about you. So I figured this was something that the Board of Law Examiner, not the bar, would definitely want to know about.
Thanks. Thank you, Mr. Bell. Proceed, Mr. Bell.
So after you received exhibit number 32, the affidavit of John Coyle, what happened next?
All right. So after I received this, I immediately filed the Rule 60B motion. Because so the federal rules, you can actually judge to correct like clerical errors and stuff like that. And everyone knew. This rule 1.16 order he had in here, it wasn't, there was no crime fraud issues. So I asked Judge Prater at the time if she can correct the error. There's a typo, gave me the transcripts. Paul Messon even wrote me a letter and everything to her, and she corrected the error. And she granted the motion right away. And after that, I did sue the city, Coyle.
So this hearing right now is just for the panel here to pass along a verdict, to pass along an opinion, a suggestion of what they think that should happen. The Pennsylvania Supreme Court will have to decide whether he's disbarred, he's suspended, the case is dismissed, or he's censored.
Miller and the city, and it's just his official capacity.
What can you explain? For one, can you turn to exhibit 33, 644? The base number. You there?
Yeah, I'm good. Yeah, I'm there.
Okay. Can you explain what exhibit 33 is?
Exhibit 33. So after I received the complaint, or excuse me, the false declaration, Mr. Coyle publicly accused me of misconduct and made up a story. He apologized, and this is a sworn affidavit that he submitted under the federal rules. Because I filed motion for sanctions against him, and I sued him and the city, and Judge Prater corrected the error. Once he got notice of that, he changed his story up. And I think he changed his story after Judge Prater, because and once she got this, she wanted to, she scheduled hearings now. But yeah, this is his apology where he got caught. I think he's only apologizing because he got put on it.
Got it. And the title of that is, what's the title of that affidavit?
It said affidavit and request to strike of John J. Coyle. And I'm sorry, go ahead.
So Exhibit 33, this affidavit and request to strike, how is that connected to Exhibit 32, his original affidavit?
His original affidavit, he tried to throw me under the bus. And I figured it was retaliation for me challenging him at that lawsuit. And then especially the comments that he made, they wanted me to sell that case for a couple $1,000s. So once I filed my response to this and had the judge correct it and I sued him, he says he looked at the record and he took everything he said back. But he wasn't even at the hearing. So I don't understand how he had a memory of something. People have recollection issues sometimes, I get it, but he created a whole version of events in that other affidavit. And he's taking it back because he got caught in here.
Now, did you have a separate hearing about the false statement?
Yes, Judge Prater ultimately held another hearing, yes.
Can you refer to Exhibit 34? That's case number 648. And what is Exhibit 34?
This was the evidence Judge Prater had in front of her when she made her ruling on at the hearing on this false statement made by John Coyle. And it was just the evidence of Mr. Messon providing the court with why he withdrew from the case.
Can you look at page 652, line 5? Do you see that in the transcript?
Yeah, do you want me to read it?
If you can.
All right, so question. Mr. Messing, did you tell Judge Dozell that I asked you to commit a crime of fraud? Answer on line 7, I did not.
Yeah. So, what did the judge do after Paul Messing confirmed to the court that you didn't ask him to commit misconduct?
So she granted the city's motion. So she had all right. So after Paul Messon testified, and I'm happy he was present, and thank you, Paul Messon. After he testified and told and confirmed that her original order correcting the typo was appropriate, and she had the judge had John Coyle's affidavit, and he apologized to the court for lying. She entered the order and said Paul Messon withdrew because I asked him to commit a crime fraud, despite what was the evidence she had in front of her, and the city didn't offer anything. They just offered John Coyle, apologized that he lied, and she still vacated her prior ruling and entered the crime fraud ruling against me.
Can you turn to Exhibit 35, page number 663?
I am there.
All right. What is that?
This is Judge Prater's order that she issued. Can I make a clarification, please? I think I made a mistake in my testimony. I think earlier I said I filed it pursuant to 60B. Apparently it wasn't. It was Rule 60A. So I don't want to nitpick that, but I mean, you know. This is the motion that, this is the order that she entered like right after the hearing. And I had to report this to the Board of Law Examiners, not the bar. This is, And on the second page, she lists that. Can I read some of the footnote? It's your direction, sorry.
Yes, please. I'm asking you how this pertains to
All right.
Accuses.
So I'm at footnote number 1 on the back. And going to the second paragraph, where it says to be sure. It says, to be sure, John Coyle's affidavit was not this. I'm sorry, let me stop it. All right. To be sure, John Coyle's affidavit was not the City of Law Department's finest hour, but in light of all the circumstances, including both this court's order striking the affidavit from the record and this court's speedy grant of plaintiff's original Rule 60A motion, the court concludes that sanctions are not warranted. So the judge denied my requested sanctions. I produced to the court evidence that there was not a basis for this crime fraud labeling of me. And she still entered the order, and at the hearing, the city didn't offer any evidence to justify why a prior order should be reconsidered. They just said it was gonna hurt their case because at this time, the court was aware, because the city informed them that I had filed a lawsuit against the city and Michael Miller for submitting the false affidavit on behalf of Coy. So they were talking about she was aware that there was a lawsuit pending and Michael Miller was a defendant in it.
Okay, so I know it's a lot of different lawsuits to try to keep a hold of. So back in the 90s, he gets frisked and arrested. He doesn't like it. Pro se, he sues the police department and wins. Enough money to become a lawyer, he becomes a lawyer. Back then, those people that were involved in that case said, this ain't over. We're going to get you. This is not over. Now, fast forward to the last 10 years, he's losing cases he doesn't think he should lose. And he's losing them when the parties involved are these people that were in the original lawsuit that they lost back in the 90s. Miller, Anders, Coyle, they were all part of that. And now, whenever he gets in front of a judge, like Judge Anders, who is involved, he loses. Now, if you don't show up for an arbitration meeting, you're going to get a default judgment set on you. That's just facts. But he's saying they have a vendetta out against him because of all of this. So every time he gets into a new case that involves one of these and the case ends, he is reporting them to the bar and getting lawsuits against them for false documents, for just something that happened during the case. So it's like a snowball. Finally, Judge W. Can't remember Judge Wilson. I don't remember. Finally reported him to the bar, to the Office of Disciplinary Counsel, And that's why they have this against him. So what he's doing right now is he is putting on his evidence. This is what happened. These are the cases with these people ever since that day, and they definitely have a vendetta against me. That's what he's trying to prove right now. And they're bringing up all the lawsuits, which we're not allowed to hear a lot of them. But we'll continue tomorrow. Thanks so much for coming out, guys. I appreciate it. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain. 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guarantee.